ene ampire ebedwa ewo Supreme Court Samuel Atta Kyea and then the client Kwabena Adu Boahene in the 49 million the state versus Kwabena Adu Boahene case. No, almost a judge now what case in the 20 answers. Almost a judge and a bias. And until last week, Samuel Atta Kyea in open court, I walk out of court. If you cross the general legal counsel, lawyers, and then money any adian, I won't friend. Na senior lawyers and them credit which na judge Kasama and co-offend to walk out of court. Sign the bika. Na asam na nkasa te senti a Kwabena Adu Boahene ne lawyer Samuel Atta Kyea say judge ni bias omo sesa judge no eno ka ho no walk out of court no me the same reasons nya bebrel again no ene what we should expect from the Supreme Court omo ne Samuel Atta Kyea ne client be ya adwen anazom ne nadwen emre ene nkrabia ene be kire but dan nkasa na wo suit nim anasa application na Kwabena Adu Boahene ne client Kwabena Adu Boahene ne lawyer Samuel Atta Kyea dey akodan Supreme Court no eno enam no bebobo hu ye from you no say tutu mesro so be subscribe am subscribe no click bell notification no me the video bi atuma obehu na watini ahwe bi we are no aja comment in the comment section no akọ app any Play Store wanna pan rate ko download na fa di dwuma no na bebo opese hu all the major remitting platforms on rate on the mawa eno ene bebo awo na wa click na obi di dwuma no na wo de adu dwuma. Last week, exactly any 1 week on the 23rd of October, in Mako High Court, I want to assemble state in the Kwabena Adu Boahene 49 million bills or the court of soft woman which money laundering born any idea. Yet, Samuel Atta Kyea walk out of court. Didn't know walk out of court any.
In the court since 9 o'clock, as scheduled by the judge, we didn't see the face of the attorney general. Other cases were being adjourned, we were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment, and that he is ready to continue the case. As to why the judge is in an ambulance mood to continue the case, I cannot wait for the Supreme Court for 1 week. The list married to the design, and I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case, and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And then, leave him to do what he wants to do best. That's why I've left the court.
Are your client not going to be? Your client is still.
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there. Because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But Counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter, in which there is an old authority, the Supreme Court has departed from the authority, and the Supreme Court in 2020 is asserting that when there is a pending application for prohibition, and the lawyer tells the judge looking after the affairs of the case that, look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased. If you see the Supreme Court decision and you don't want to respect it, I can't force him to obey the Supreme Court, which is at the summit of the justice delivery system. But I think we'll have a day in the Supreme Court.
Yes. It was say, yeah, the assembly could Supreme Court no. court ba tan and kasam high court na ye kasam na ye inferior court no judge ne se chinchina opeso otena sem ne so ana Atta Kyea say yes enye de menti ase because akam na ketewa bi Supreme Court be rule umu judge ye no wasem de da enti denti na be se chinchina wotena asem ne so. But you see, it is coming from a certain place. Someone Atta Kyea na ne lawyer no ese judge no tia asem ne so na Justice Eugene Nyadu Nyante no omu nyinini again request bi na so de more grant wom request for adjournment and so no want tia so di case no expeditiously ekonanim Atta Kyea na ne lawyer no ene ne client say omu sha papa no oye bias ase oni state no prosecutor na ekonakra na bi pesa so omu pesa omu ye bibia ntentem bi omutimi ko conclave ko cancel bi ono we defend the client no oni wo bi yo be hu ane say prosecutors no every court oba every judge ne dem oba any ade enti ade ni se gidie nim. The summary of everything is that gidie nim. Now right no mo dia come Supreme Court no Paul will be in a better position to know these things. Enti tie don't watch on why Atta Kyea and then the client Adu Boahene enye judge nini no enuni.
Kwabena Adu Boahene and his lawyers are concerned about the demeanor of the judge at the High Court. They are alleging that the judge is not. They are alleging that the judge's role is not being played the way they expect it to be played. So Kwabena Adu Boahene here and his lawyers have brought legal action against the judge. And tomorrow the Supreme Court will be hearing the application, inviting the courts to endorse their suggestion that the judge be removed and the new judge placed there. It's part of legal procedure that you can ask for the judge to be removed and another judge placed there if you feel that the judge has exhibited bias, unhealthy bias against you one way or the other. But you have to cite cogent reasons why you think the judge has done so. And in the affidavit attached to the writ, Kwabena Adu Boahene cites those things. Let's look at them right here at the beginning. This is this is the Attorney General, the Dr. Dominic Ayeni, the Learned Atta Kyea Counsel for Kwabena Adu Boahene, and this Deputy Attorney General Sremsai. All three of them very critical to the matter. Now, Adu Boahene seeks an order of prohibition against the High Court judge in the matter of the Republic versus Kwabena Adu Boahene. That's the way they say it in law. He's looking for an order to prohibit the judge from continuously sitting on his matter as a High Court, as a trial judge. They want the Lord Chief Justice to change the judge. If the panel of Supreme Court tomorrow were to agree with Atta Kyea, then the Lord Chief Justice will have a duty to remove the judge and place another person there so that the trial can continue. So what are the reasons that Kwabena Adu Boahene is given or is asking for the courts to agree with him? Now, these are the summary of the reasons, and we'll go into the details in a minute. Reason number one, Kwabena Adu Boahene and his lawyer said that the High Court judge has shown bias by holding court sittings with the prosecution present while Adu Boahene was yet to be brought into the courtroom. They are alleging that. Two, they say the High Court judge has shown bias by insisting that he continues with the matter while there is a pending appeal against his decision. We'll explain this in some detail in the next page. And then number three, it says the High Court judge has shown bias by preventing Adu Boahene from having access to important evidence needed for his defense. So the High Court, so they are saying that the High Court judge constituted court at 4:30 p.m. They were not aware. They were bundled into a car and sent to the court. By the time they got to the court, they saw the Deputy Attorney General and the Attorney General suggesting that these important prosecutors were aware and that they, the other side, were not aware. They believe that is offensive to the Criminal Procedure Act 30, I believe. The second one, they are saying that the High Court judge has shown bias by insisting that he continues. So normally when they bring an application before a High Court judge, he can have a decision on it. He makes his decision. If the parties don't like it, they go to the Court of Appeal or the Supreme Court for a review of that decision. Now, they're saying that whenever that happens, typically the judge must stay the proceedings and wait for the court, especially if they are saying that without this matter, we can't move on to defend ourselves. The judge says, I don't mind, go ahead and defend yourself. But if they sue, as they say, they sue upstairs and they're asking for a judicial review on the matter, typically the judge should hold. But they say that the judge says here, he says he's not willing to hold. Okay, so let's get into the details of the grounds. Ground one, which is ground one is the High Court judge has shown bias by holding court sittings at an odd time. This is the case. On 30th April 2025, Angela J. Boateng, Charles Adu Boahene, and Mildred Donko and their lawyers were invited to meet officials of the Economic and Organized Crime EOCO. But after a 2-hour wait, they were unexpectedly detained by armed EOCO personnel and taken to the High Court, despite protests from their lawyers, Samuel Atta Kyea and Kwame Osei-Asare and Peter Osei-Asamoah. They were ushered into General Jurisdiction Court 10, that's a courtroom, where the Attorney General and his deputy were already present. The lawyers, caught off guard and not formally dressed for court, were served with the charge sheet and prosecution facts that had been filed earlier the same day. In violation of legal procedure requiring prior notice, it will mean that the charges were filed and the court made aware and made to sit the exact same day. The presiding judge, His Lordship John Eugene Nyante Nyadu, proceeded with the arraignment despite objections, and the group exited the courtroom at about 4 p.m., at about 6 p.m. Now, Kwabena Adu Boahene is saying that this is untoward, this is not part of the legal procedure. You don't surprise an accused person by asking him to come to an investigative agency, EOCO. He's at EOCO for 2 hours. He finishes, hey, come and sit in this car. They sit in the car, they are put in the car, and they are sent to a courtroom. Then the Attorney General is already there, the judge is there. It's past 4 o'clock, normal time for the court to close, but this judge was sitting waiting for them, and then they served them with the charge sheet, etc., etc. So that's ground one. Ground two, that the lawyers of Adu Boahene filed an application praying the court for an order directed at the Attorney General to disclose all the pages of evidence required. This included some pages of a bank statement produced by the Attorney General, as well as evidence of certain procedures that are used by the national security architecture. The application was because some of the pages of the documents provided by the Attorney General as evidence against Adu Boahene had been deleted and could contain important evidence to prove his innocence. Further, the court's order for national security to disclose its procedures would have aided the defense, show the court that what Adu Boahene did was standard practice in national security architecture and was not theft. So on this one, the Attorney General brought a document to the court to prosecute Adu Boahene. It's a bank statement from one of the banks. Now, the bank statement has about 100 pages, but the observation was that about 90 pages were taken out, and the court didn't see it. It wasn't in it. So the Adu Boahene's lawyer says, but what's going on? You have a bank statement that has Adu Boahene's transactions. It's 100 pages. Put all there. We will show you what you are looking for. We'll show you how it works. But you have taken this substantial amount out and you are submitting to the court a few documents. I mean, if this is true, it's quite bizarre. If it's true, it's very, very bizarre. You are a defense person. They bring your bank statement and they've taken some out. How are you going to deal with that? Why should the prosecution be allowed to do that in a democracy and in a normal court practice? So they are arguing against that. That's not correct. I mean, if this is true, this is very serious. Also, they say that the things that you are accusing Kwabena Adu Boahene for is a standard procedure of the national security architecture. Bring the national security people in. Let us ask them whether this is not their procedure. Whether in 1993 they didn't do the same thing. Whether in 2016 they didn't do the same thing. Whether in 2011 they didn't do the same thing. And then the prosecution says, no, I'm not going to do that. And they make an application to the judge. The judge says, I'm not going to allow you to do that. It is as if you want to tie his hands behind him and shoot at him. You don't want him to be able to defend himself, because the material that he's going to use to defend himself is within the bosom of the prosecution. Sometimes they call it discovery in legal practice, but Adu Boahene is complaining about this as a second ground. The third ground, Adu Boahene says that okay, so on the second ground, where they are not allowing him to defend himself, he's relying on a recent case of Republic versus Bafuboni, in which the current acting Chief Justice ruled as part of the matters, and it was said that they should allow the prosecution should give to the defense anything that the defense needs that will be needed for the evidence in aid of the defense case. Prosecution and the court should allow the defense to get everything that the defense needs, even if they have to get it from the prosecution, which will allow and aid the defense of his case. So Kwabena Adu Boahene cites this as the reason why he thinks that the judge should comply and allow them to get the full document of the bank statement and also the national security procedures. They should bring them to the court. Now, on the third ground, he says that upon refusal by the court's order, the Attorney General to provide full disclosure, Adu Boahene's lawyers appealed the decision by the judge, insist on continuing. Adu Boahene appealed the decision by the judge. I appealed the decision, but the judge insists on continuing the trial despite a pending appeal before the Court of Appeal. This is all on the backdrop of the judge acceding to request to the Attorney General to deal with certain matters earlier than has been fixed for determination in the court. So this is very, very, very concerning. Here, Adu Boahene's lawyers are saying that based on the fact that the judge says he will not allow them to get the full bank statement, they filed an appeal to the Court of Appeal, told the Court of Appeal that, look at this, we need this to defend ourselves, but the High Court judge says that we are not entitled to it. Now, whilst the Court of Appeal is preparing to hear the matter and give a decision one way or the other, the High Court is continuing with the trial, that whether you have it or not, I'm moving on, I'm going on with the trial. He may go on the trial and get to the end of the trial, whilst the Court of Appeal is yet to bring the decision down. So they are saying that, no, let's go to the Supreme Court and say that based on all of these demeanor findings, we believe that this judge should be prohibited from continuing to hear the matter. The Supreme Court hears the matter tomorrow morning. Good luck to all parties. But
yes, it's the summary of GDN. And today we are expecting the Supreme Court to rule. So I'm best to judge, and now so monster judge, that is what the Supreme Court will be ruling on. And normal, I think so. All kind, Danny, and they didn't cry the Whitechapel Papa not in the case. Echo and the Echo Bank matter, and I'm so a dear Chief Justice said, also at a point or requested say yes, judge, even the former Chief Justice, Madam get to talk on Eric Kusuno, open trial, and there were judges CBA, and also so all these things happen. The court in the bid said that they be American about prejudicial matter there. I don't know information, I can't put everything across because the matter is sub judice, it's still in court. It's near all on judge ni. Osha Atta Kyea post channel to acquire judge and a pentemodo. And also na Ghana for open no rasa judge no be any asam no ententem. But anything they the Supreme Court no, the apex court of the land, court bar time and kasana. And number really on this matter. Many exclusive on it. On the critical analysis and him say, yeah, the bro. Three and a number some the bro. Subscribe me, na click on notification me. The video be to man. Obe who now what me I should be. Send me kind we are no comment in the comment section. And you'll be at them. Let's do it decorously. Why? And send it be American. Me here Ghana so to show see mommy. Bye bye.